Good afternoon, everyone. Welcome to the session today. We're just about to kick off. We want to give people an extra 1 minute. We'll give them to get logged on. There's attendees still coming in. I see the number clocking up. So as people are coming into the session, I'm just going to my role here is just a very brief introduction. To give this a context, I was asked by a client of ours, a software company, a software product company, an Irish company doing lots of business in the UK, and kind of some US software companies or tech companies generally, what do they need to know about Brexit or what might happen. And within this context, the simple question is, what's the difference for a tech company post-Brexit? Now, of course, we don't know what's going to happen with Brexit right now, or I don't. But see, what's the difference for a software company? And that's the simple question that I emailed off to Mike. And we thought that obviously it's an interesting topic to all tech companies, whether they're UK-based, EU-based, or dealing with the UK right now. So this is the context of this session. So the experts we have on this, on the call, is Mike McGrath from Arvo. And I'll let Mike introduce himself. And we have Michael O'Dowd, which is a legal solicitor in this particular space. And both these individuals work with companies in supply chains and within the Gdpr related areas. So on that, I'm going to hand it over to Mike, and Mike will host the rest of the session. So thank you, Mike, and Michal, I'll leave it to you. Thank you.
Thank you for that. I appreciate the introduction. And we mentioned starting about introductions, just for people to know. Arvo is a procurement company here in Cork, and we've been working on Brexit-related matters for the last 4 years. It's amazing to think when we started on this journey 4 years ago that 2 weeks out we still wouldn't know what Brexit will look like from a free trade point of view or a relationship with the UK. And more recently, a lot of regulatory items have come up. So we've been working with clients around issues around Gdpr, around CE marking, around REACH, and a lot of diverging standards, which are implications of the UK becoming a third country. So Don and I spoke about Gdpr and data and the transfer of personal data to, from, and through the UK per se. And we decided to host this event. When we were engaging with clients in data protection and GDPR matters, we would lean on Michal O'Dowd, and Michal can introduce himself as well as a data protection expert locally. So Michal, do you want to introduce yourself, and then we can go through some of the issues that we see from GDPR and talk through how clients can get prepared, or how IT Cork members can get prepared for Brexit.
Sure. Thanks, Mike. Thanks for the opportunity to talk. My name is Michal O'Dowd, solicitor in Glanmire. I do a lot of work in the data protection space. I suppose I've been doing for years before it was sexy, as they might say. I suppose to start the very start, it's not a new thing. This the GDPR is new-ish, as we know. It's only around a few years, but the idea of data protection goes back a lot longer than that. I suppose if we were to look at the history books of data protection, we'd start off with the 1980 OECD guidelines, which really set the scene for what the GDPR is now. And the purpose of the guidelines then was to, I suppose, it has always been, privacy has always been a second, kind of playing second fiddle to the free movement of data, really. In 1980, you can imagine, we had a fledgling Microsoft, we had all these things starting up. We didn't have the internet as we know it, but the idea of data moving across borders was becoming an issue. And with that, we were seeing there was a diverging standard between the likes of France and Germany, who would have been maybe occupied countries during World War II, and what that brought with it, and the residual memory of that, and countries like Ireland and England, where we didn't really care, we were half interested in what the neighbours were doing. So the fear among the multinational community then was that that would lead to a diverging standard, and that there'd be a regulatory race to the bottom. The European Union in 1995 brought out the Data Protection Directive, and that, I suppose, brought into kind of a binding legal international instrument regulating the flow of data. And again, the idea of that was so one country would not be getting a competitive advantage over the other one. Again, so countries and continental European countries would, with their kind of their higher privacy standards, so to speak, wouldn't be unfairly disadvantaged compared to other countries who would take a lesser view. Again, I'm picking Ireland and England, I'm picking maybe Spain or Portugal, places like that. And again, fast forward to the GDPR, which we're all familiar with and sick of hearing at this stage, again, built on that. But again, if we go right back to 1980, the same standards are there. Nothing has really changed as much as we think it has. And Brexit is bringing to play exactly what they were worried about back in 1980, this regulatory race to the bottom, kind of starting off all over again, and what it means. So that's kind of historical context of the Brexit debate. And I suppose I don't mean to ramble here a bit, but the whole, I suppose, withdrawal agreement and the free trade agreement and everything to do with the GDPR is almost a microcosm of every single issue related to Brexit right now. And yeah, we don't have a clue what's going to happen, but we can have a fair guess at it. Sorry, it's a very long answer to that question.
No, I appreciate that. The context helps and the history relevant too. So from my understanding, and one of the issues around Brexit and the UK's exit from the EU is their journey to diverge from standards and to set their own rules. That's a primary focus for the UK in the future in terms of setting their own rules. And does that include setting their own rules about data protection and privacy?
Exactly, yeah, that's exactly what. So they're starting from a position where the EU, and I'm going to use the word EU GDPR for a particularly good reason, that as of today, the EU GDPR applies in Ireland, it applies in the UK, it is perfectly well implemented in both Ireland, in the UK, and in most countries in Europe. So everything is harmonised as of now. There is equivalence, which is a slightly loaded word, so to speak, but there is that there now at the moment. And yes, the idea of Brexit, or what was being contemplated in the Withdrawal Act, is that it's a fabulous exercise in copying and paste, or find and replace, maybe in Microsoft Word. The word EU GDPR was found and the word UK GDPR was put in its place. And then throughout the text of the document, the word Union law was removed and United Kingdom law was replaced. So that's their starting position. But I suppose the fear is, and it's going back to exactly what is happening with I suppose where things are, the negotiations are at the moment, is that as of now that's fine, but where are we going to be in a week's, well, we won't say a week, what have we now, the 16th of December, in 3 weeks' time, let's say, will the same framework apply in the UK and in Ireland, or will it be different? That's the question we don't know the answer to.
And just playing devil's advocate, then, if it is different, if there isn't that equivalence or adequacy between the UK and the EU, what does that mean for the movement of data to the UK and from the UK?
So at the moment, yes, the EU, state the obvious, the blindingly obvious, the UK is part of the European Union. In 2 weeks' time, it won't be. It'll be a third country. The rule regarding that has been that the European Commission has carried out its investigations to establish if a particular third country has equivalent protections to what is in the EU. If it had equivalent protections, then you could transfer information freely. Countries that would have a recent one that would have been found to have an equivalent protection would be Japan. Israel is one that stands out, and there's various ones scattered around. Don't ask me how many. I'm going to say something in 7, 11 of them there. One that isn't there is the US, which is a slightly different issue, which we might address in a while. And also the UK isn't one as of right now. I would be of the view that the reason it isn't one is a political decision, because right now they all implement, the UK implements the GDPR the same as Ireland does, or the same as you. So it is equivalent. But I suppose that the issue is, or maybe the slightly concerning thing, or if you were in the European Commission, what you'd be worried about is maybe some provisions of the UK GDPR. One of them would be the inclusion of what's called the Henry VIII clause, which allows the Secretary of State in the UK to change it unilaterally. That's a huge issue. The existence of Henry VIII clauses goes back to obviously the time of Henry VIII, when he said he had supreme power to change any rules irrespective of Parliament and so forth. The problem with that, of course, is it allows legislation to be changed quickly and easily, and sometimes means you don't even know what the legislation is. And I suppose the other concerning thing from a European context is that there has been certain inclusions in the Withdrawal Act for giving access to security services and so forth to information which heretofore they would not be permitted to have under the GDPR. Still and all, I'm not sure if that means they don't have equivalence. The Israeli data protection regime is quite deferential to their security services, and that wasn't a problem to the EU. So in the heated hunt, I think that the decision will be made. There is equivalence, and I would imagine there'll be some fudge saying that, look, yeah, that they'll maintain equivalence and they'll try and keep in step going forward. That's what I'd imagine will happen, but we don't know that right now.
Okay, so Japan and Israel and other countries have an adequacy agreement, and
yes,
the UK are seeking one at the moment. If they don't get it, what's the challenge in for Cork companies or IT companies here in Cork if they're processing data on behalf of UK citizens? What needs to change? What needs to happen for them to do that in a compliant manner?
Yeah. Well, firstly, the UK Information Commissioner's Office, or the ICO, who I will add have some very useful guidance materials for any company wanting to see what the rights of UK citizens are. They've published guidelines on that, but they also have made a decision that there will be equivalence. So they're saying that the EU GDPR is every bit as good as the UK GDPR, which obviously stands to reason because it's the document from which it arrived. So there is no concern there. There is the idea within Article 27 of the EU GDPR, and I presume it's in Article 27 of the UK GDPR, the idea of there being a representative, and the idea being that maybe you may need to have a representative in the UK to deal with things like subject access requests and so forth. The ICO have kind of have said more as on record they're going to take a very benign approach to that in the initial few weeks and months. So personally, I wouldn't be running out to worry about that just yet. If it transpires come the middle of January, the middle of February, we're not looking too good, and that there's a slightly firmer view being taken, and maybe certain companies will need to see, do they need to take steps or get in tow with certain UK organisations. But as of right now, I don't see that being an issue.
Okay, so I asked you a question there, I suppose, about an EU company processing UK citizens' data, and that doesn't seem to be a risk yet, because ICO and the UK are recognising EU GDPR. Again, playing devil's advocate, if the EU don't recognise the UK GDPR, what if a UK company, even ourselves, we have a CRM system, and a UK company, they have persons who belong to us here, Irish citizens' information is on a platform hosted in the UK. What's the risk potentially there, or what can be put in place to mitigate any such risk?
Yeah, and that's a very realistic issue. Even in my office, we've come across that issue already, where we'd have outsourced typing, which is a fairly innocuous thing, where the solicitors might need to type up a letter, and if we don't have enough admin support, that it's just being typed by a company which is a UK company, and I don't know where the stuff is typed up. But yeah, so in that particular case, I'm going to give that as a simple example. There is a contract has been circulated by that company who would be a data processor. And I'm taking as read people understand the idea of a data controller and a data processor. So it's just a standard contractual clause agreement where they're saying they're going to protect the information in a reasonable way, with equivalence to the GDPR rules and so on and so forth. So that is closing us off from I suppose from any concerns we'd have with the withdrawal agreement or what's going to come there.
Okay, I appreciate that. I'm asking a lot of questions here, and I'm conscious that 1 or 2 questions have come in, so the audience can use the Q&A feature as well to pose any questions to Michal. I'll continue with a few more questions for now, and then we'll open it up. Just in terms of when we're looking at GDPR with some clients around UK data transfers, the concepts of standard contract clauses or binding corporate rules, etc., have come into play. So how appropriate are those, or what's the requirement of those, and can you even explain what they are for those that may not have come across an SCC or DCR?
Yeah. So the SCC, or the standard contractual clauses, is reasonably well known at this stage as a method of transferring data to a third country where there may not be adequate protections in place. I think the IAPP found that for all such transfers, about 90% of them were on the basis of these SCCs, or these standard contractual clauses. The BCRs, or the binding corporate rules, are a slightly different beast. More complicated, and probably, look, if you're using one, you'll have an army of lawyers in your in-house legal team. So I'm not going to say more really about them, except they're there. They involve where you have a multinational company with various branches that you can set in place an internal framework. The data protection regulators in each country are involved every step of the way, and they are. I think they appear to be. I won't say foolproof, but they're quite expensive, and even in light of the Schrems decision, which I know we'll probably mention in passing a while, they seem to have survived that, or they weren't affected too badly by it. The standard contractual clauses are simply a formula of words that you will use in a contract between a data controller and a data controller, or a data controller and a data processor, which should protect you from the worst ravages of the GDPR if you're transferring information to a third country, be it to the UK, or be it to America, or be it to somewhere else, after Mongolia.
And in terms of those standard contract clauses, it sounds like it's a standard contract. Is it a defined template that's within the GDPR regulation?
It is. It literally is a defined template. It predates there's about 3 of them there. I think they all predate the GDPR. They do all predate the GDPR. There is revised ones being bandied about. None of them have been formally adopted yet. But they're there. And they are literally copied and pasted into. They can be used on their own. They can be used as part of a bigger data processing agreement. It's frowned upon they being amended or altered. The only thing, I suppose, that and I mentioned in passing the Max Schrems decision, who's a I think Austrian lawyer who has a keen interest in privacy and has made life pretty difficult for Facebook, among others. I suppose there was a decision earlier this year from the European Court of Justice which concerned these standard contractual clauses. It did 2 things, the Schrems decision. The first one was it outlawed the privacy shield, which was which we'll talk about later. But the more important thing, I think, from our point of view, was it put in place, or it required a little bit more thought being given to the standard contractual clauses, rather than just bending them about and saying, yeah, you sign this, and the data controller in your data processor in UK or in the United States, you sign that. It required a small bit of thought be given to the legal regime in the third country, to, let's say, the powers of the supervisory authorities there. Again, a small bit more research done into it, and a small bit more thought, rather than just blindly following the standard contractual clauses, is what's required now. So if one was to use them, again, they're perfectly good. They were upheld as being valid, but they're, they do maybe have a slight health warning that you need to make sure that who you're contracting with, that it's appropriate, and that you know where the information of which you're a custodian, where it's going, and what might come of it, if that makes sense.
Yeah, no, that makes sense. And that Schrems 2 case hit the headlines a lot, and the implications for GDPR were interesting, particularly around Brexit and the UK becoming a third country. You mentioned the privacy shield aspect of that Schrems 2. Do you want to just finish up on that before we move on to the...
Yeah, look, there's been various efforts over the years to make the United States be make it be equivalent to the European data protection regime, whether it was in the old directive and Data Protection Act we had 2003 Act, or whether it was under the GDPR world. The first one, of course, was the safe harbour, and that was found not to be compliant with the European data protection regime. And in the second bite of the cherry, the privacy shield, equally met its Waterloo at the hands of Max Schrems. Again, the issue being in that case, I suppose, that there was no way to safeguard citizens of the European Union or their rights in the US. So if the data was used or misused by an administration there, that there was no effective remedy for anyone in the European Union from that. Look, that issue hasn't been solved. The SECs, I'm not sure if they solve it to a huge extent. I think the finer points of the Schrems ruling was that if a data processor, I'm going to pick the US, has become aware that that their information is being accessed by security services or whatever, that they're not obliged to inform the European data controller, but are obliged to say, look, we cannot guarantee compliance with the GDPR, compliance with the rights of the data subjects in question. So that's what it's kind of doing, or that's what has changed around a bit. So, but it's not stopping anything. There's still data flowing in and out of the United States. Good, though, it's not, once the boxes are ticked and once there's a small bit of due diligence done, I don't think it's anything to be too concerned about, quite frankly.
Okay, that's slightly concerning, actually, I suppose, to learn that there hasn't been any changes, that the data is still flowing under this faulty regime, but hopefully it'll be ironed out. There is a question come in there which is really relevant to this topic, so I'll ask it now. Thanks, John, for asking the question, and a reminder for anyone else that wants to pose the question. The question is, isn't there a potential GDPR issue with the fact that the UK will share information with the US? So there's a belief there that UK information will be shared with the US. Isn't that effectively the potential GDPR issue that's at play here?
Yes. Well, I suppose, you see, the issue is that the equivalence regime that we're familiar with in the EU GDPR involves the European Commission or the Data Protection Commission or reviewing the framework that is there for a third country and make a decision that that's okay. The copy and pasting exercise carried out by the Individual Act gives that power to the Secretary of State to sit down some morning over her coffee and decide that a particular country is equivalent. So, absolutely. So it all made sense when the GDPR was a community-wide project. It doesn't really make sense, and this is maybe going to exactly the heart of the Brexit negotiations, where you have two organisations. You have the European Commission on one side, and you have the United Kingdom Secretary of State on the other, neither talking to each other and both deciding that there is equivalence in protections for the exact same legislation. So, yeah, it's something to be teased out. I would anticipate that there will be some agreement on mutually agreeing what equivalence is between the GDPR, the UK and the EU GDPR, because otherwise it'll kind of fall to pieces. So yeah, that's a reasonable question, and we don't know the answer. But my best guess is that there will be some protocol where there'll be mutual recognition, or there'll be some fudge. So there won't be two sets of competing company or competing country lists are emerging.
Okay. That'll be easier for companies to manage in future. We mentioned there about some of the safeguards around GDPR, the SEC and the binding corporate rules. We're working with a client in Dublin, and they resell a lot of software in the telecom space, and a lot of the data they attain from across Europe is quite complex in terms of where it's being held and where it's processed. And there's other safeguards. I'm just wondering if you wanted to comment on any of those, and the ones I've come across is the ad hoc contractual clause within GDPR. There's also a code of conduct that could be introduced, or certificates. Is there any of those that you would have our companies embarking on those, or are they really theoretical in terms of lacking practice? Really, is what
Look, the GDPR is actually very straightforward in terms of what the basis of it is, of how every part of it works really. If you're processing information, you're either doing it on the basis of consent or you're doing it on the basis of legislative authority. Most of the work I've been doing has been in the public sector space, so we've always all been worried about legislative authority, and consent we've always viewed as being bad, because consent can be revoked, and if someone gave consent, they have to be able to revoke it again just as easily in the GDPR framework. Contractual clauses, all these things don't, to my mind, solve that fundamental issue. You still have, I suppose, a data quality issue when you're collecting information that is being, at the point it's being collected, that the person, that the data subject knows it's being collected fairly, that it's being processed for no more, for the purposes for which it was collected. There's nothing you can really do after the fact to make good information that was collected badly, if that makes sense to you. I view it with skepticism. Sure, there is an awful things there, particularly in I suppose the direct marketing sphere and all that, which do help and which guide companies on what they can do and can't do, and how they can use their information, how they can't use their information. But at the end of the day, I would say the most important thing is that companies do audit what they have and know what information they hold, and know the purpose of which they hold it. And if my best example when I was teaching undergraduates in UCC was Brasserie 66 had a little voucher when you booked, and you gave your mobile phone number, to make sure you're going to show up for your table. And if you didn't show up, they'd ring up and say, "Are you coming, or can we hand it over the table?" And they started using that little phone number then for marketing. And of course, they were told on about 2 or 3 occasions that no, you can't do that. That information, that phone number was collected for one purpose. You cannot use it for another purpose. And they're ultimately fined a small amount. But this is going back a few years. But I always think it's the best example of what you cannot do, no matter, full stop.
Yeah.
In terms of derogations or so on from the GDPR, there isn't really many, unless you're a state agency. Unless you can point to a useful piece of legislation which says you can do it. For instance, the Gardaí, one example, better example again, the revenue commissioners do whatever the hell they want and process whatever the hell they want in almost any manner. You're stuck in with consent. Yeah, sir. Really and truly, full stop.
Fair enough. You mentioned there a good point about doing an audit and understanding what data companies have and process and why they have it, etc. The concept of a DPIA, is that what you're referring to, a data protection impact assessment? And if discuss it, I suppose, introduce it to the audience really what a DPIA is and the process around undertaking it, and that would be very helpful if you don't mind.
Yeah, the DPIA, look, there has been a cottage industry, I know, has built up with data protection, and plenty of companies and consultants and all the rest offer services of doing data protection impact assessments and so forth. They're useful. They have a certain footing, particularly where the sensitive data is being processed. They're useful for companies. And look, I suppose the important thing to say about them is there's no hard and fast rule about what they involve. In some cases, it's very, very straightforward. If you are engaging in processing where there may be a risk to the rights and freedoms of others, yeah, you may be obliged to do one. But again, you can follow a framework. There's various trade organizations and so forth have published various frameworks for doing them. There's nothing really right or wrong in any of them. But I suppose the main thing is, yeah, you look at what you have, you do an audit of what information you have. It could be, we did a fairly large one, a couple, probably 12 months ago at this stage, where we started off interviewing lots of managers in the organisation, seeing what they did. We wandered around the organisation. We all wandered around the building, saw what was going on there. We started poking filing cabinets, and then I suppose finished off getting kind of people with database knowledge and seeing what was going on with the database and who could access it and what could they do with it. Some of it was, well, to be fair, most of it was on the basis of the organisation themselves, saying what they could do and couldn't do, and the infamous share drive made its odd appearance here and there. But there's no hard and fast rule to it, but I think it should be done systematically. And certainly if you're gathering huge data sets, if you can show that you know what you have and you know what you're processing, and you even know what your risks are, and that you took certain steps for them, at least if something bad goes wrong, you can point to that. You don't look like you were completely negligent and not paying any attention to what was going on, and you did not know what was happening. I can't see how a data protection commission or commissioner could have a huge problem with you.
Fair enough, as long as that the DPIA is thorough, it's asking the right questions, and producing an effective report in terms of that assessment is probably the practical approach. Exactly,
and it should be a living document. It's you know, it's something that you should be reviewing on not a daily basis, but you know, as your data processing regime changes, that you would be reviewing it and you'd be changing and updating it and saying, okay, well, we were getting data from these sources before, now we're getting them from these additional sources. You know, are these sources compliant with GDPR? Are they coming from a third country? What are they? Have we engaged a new processor? Have we moved from a processor in France to a processor in Zimbabwe? What are the implications of doing this? You know, so that's how you, to say how you would do one. I think I'd be wronging the regime, because for sure the GDPR doesn't set out a framework as to how you do one, and it doesn't say what's a good one and what's a bad one, but it says you should do one, and obviously you should be methodical in how you go about it.
Yeah, it sounds like there's no template. So for DPIA, it's very much appropriate to the size of the organisation, the volume of data, the different individuals that have access to it, wider processing, etc. So it's more flexible than
absolutely. And I said there is certain formats that certain consultants follow, and some are fine. They're good. I suppose I come from this from a lawyer's point of view, which is looking at the words on the paper and all the rest, rather than trying to fit sometimes the data into those words, which doesn't always fit, because there's often a more holistic answer to saying, look, this is a risk, it must stop, or this isn't a risk, it must stop. I'm slightly going off topic here, but we had a large breach that we advised on some time ago, and the question was, okay, the information was accessible, but was it accessed? And the Data Protection Commission was pushing that we had to notify all our data subjects, which we didn't want to do, because we said that would create a lot of, it would certainly have made the news and it would have been an absolute mess. And we pushed back against it, because we said, well, let's look at the server logs. Let's see, was there any change in logs? Did anyone actually access it? Okay, our doors were open. Maybe just walked off without actually coming into the barn. And that is, we were happy enough that that's what happened, and the Data Protection Commission wandered off into the sunset, and you know, shrugged their shoulders, and fair enough, right? There wasn't a data breach, but again, you know, I'm just giving that as an example of where the answer isn't obvious really at times as to what's right and what's wrong.
Some practical
approach.
Important, yeah. Okay, listen, I'm conscious now you and I have been speaking for half an hour, and we want to give the chance to the audience, if they have any questions, to put them through to the Q&A feature there, and Michal can speak to them separately. Maybe if it's a personal question, or it's a question not for public consumption, O'Dowd.ie is Michal's website, or the company website, and you can contact Michal maybe afterwards. I've just one or two questions myself. You mentioned earlier the possibility of having to maybe requiring a representative in the UK, or even, I think so from what you discussed as well, it's probably more likely that UK companies might need a representative in the EU.
Possibly, yeah. That's probably going to possibly the more likely option.
Yeah, the way the adequacy has been treated there. So just even talking about a representative in the EU, what does that look like? Is there companies here on Cork and on the IT Cork membership that could become a representative from a UK company? What's the obligations there? What's the responsibility? What's the benefit?
Yeah, I was actually I was googling them the other night. Just I couldn't find anyone in Cork. Mind you, there is one in Dublin. They charge a small enough fee for what they do. They don't have to do a whole lot either. So mostly what they'd be doing is they wouldn't have any responsibility for complying with the GDPR per se, but they would be responsible for accepting data subject access requests. Making sure that the person is communicated with, and being a point of contact. Look, in many ways, it's a bit like a company secretarial facility. If I'm to compare something people see day in, day out, it's a bit like that. I don't see a pot of gold in it for car companies, to be honest with you. But sure, if there's people working in that space, it might be something. Yeah, we'll see. I don't know where it's going to go.
Oh, that's fine. That's fair enough.
It's there already. Sorry, I should say that Article 27 of GDPR provides for the existence of these. So any US company, for instance, should have one in the EU already. If they're not already. So Facebook obviously wouldn't have them because they're located here. But I'm quite sure there are companies. There must be some US companies don't have a branch in Ireland who have them. But again, I can't see them there.
Oh, that's fine. That's fine. That's fair. You mentioned the ICO, the Information Commissioner's Office,
yes.
Earlier, having good resources. I suppose I noticed before they have an online tool, a diagnostic tool that UK companies can do a kind of an assessment on their own data risks. The Information Commissioner's Office UK is that platform. Is there other websites or resources that you refer people to? Is there any?
I would expect that once they've figured out what's happening in the whole Brexit sphere, that it'll be communicated fairly clearly on the Data Protection Commissioner's website, probably even the Irish Times. It is a fairly big issue. I think we'll learn what happens. Were I a betting person, and I'm not, because I was always pleased to the point of points, I would be suggesting that yeah, there is going to be equivalence, because as of right now, there is equivalence. I'm going to look at if we make a comparison to Israel, where as I said, they certainly give a lot of deference to security services. During COVID, there was a certain issue about it. They handed over data left, right, and centre. The European Commission didn't bat an eyelid. I don't see how they can make the argument that the UK isn't or won't be equivalent, unless, and I think the question raised earlier, how they deal with third countries, or how they deal with information being transferred from, let's say, Ireland to the UK, being processed in the US. How does the Irish company know that 2 steps removed processing is still compliant? And look, that's an issue that's still out there, absolutely.
Very good. I appreciate that, Michal. Listen, that was very helpful. Lots of information there. Lots of useful links as well for people to take note of. Again, I'll remind people, if they have any specific questions at this stage, to use the Q&A feature. If there's any particular personal data, GDPR, Brexit questions that people have on their chests. Other than that, Don, I think it's coming to an end there. I'm not sure if you have any questions yourself, Don, on data protection at this stage.
Yeah, I do. I mean, obviously, it's sort of, thanks, Michal, Mike. It's very, very complex issues for many organizations, but one business owner, software business owner, put it to me very practically, if he did nothing different over the next 3 months in his marketing and his dealing with his software customers in the UK, would there be any real harm until he really learns what's going on? That's a practical question.
It's a practical question, and I always hate saying, no, you should do this, you should do the other thing.
Obviously, you're going to cover the legal side of it.
But I don't know what you can do at the moment. To be fair, I think any organisation will be penalised for not doing something. You know, there is going right back to the fundamentals of law. There is a presumption there that the law should be obviously intelligible to the reasonable man, that you should, you know, that with a certain amount of legal advice, you should know what to do, that it can't be the case that you walk into a shop and whether you paid for the bread or not, you could still be arrested walking out of it. That can never happen. So in this case, I said the ICO have certainly expressed their view that they're going to take a very practical approach to the rights of UK citizens during this period where Brexit is coming into being. So I would say I probably would agree there's not a whole lot anyone can do at the moment.
Yes, everyone just has to keep an eye on the space.
Keep an eye on it, see what guidelines are going to come out. Look, if it's going to be a no deal, it's going to be a no deal. So be it. People have to take certain steps. Then the biggest steps I can see them need to take is appointing this representative. If they're processing data from UK, if they're let's say a Cork company processing data from UK people, that's the only obvious step I see they need to take right now. If they'll be let's say if they'll be UK, if they'll be transferring information to the UK, let's say in a data processing context, they will need to have a standard contractual clause in place that they have looked into a little bit and made sure it's okay. But that's pretty much it in a no deal scenario. That's likely what it's going to be.
Okay.
I don't think it'll add to business costs massively.
All right, Micheál, thank you very much. I will point out sort of I keep an eye on Mike McGrath's and Arvo's newsletter. I get weekly updates at the moment, Mike, isn't that right? And very interesting.
Yeah.
Sort of the political updates and all that in it. Micheál, do you have a newsletter that people could log in and subscribe to as well if you have that?
I don't, unfortunately. It's something I wasn't meant to do, but no, never got time.
We post the website links there on both the websites. So it's Mike on the procurement supply chain side of things, and Brexit's in his world for a long time. And then obviously if anyone has any questions on the more legal and data privacy side of things, data protection side of things, you have Micheál. Mike, Micheál, thank you very much. And thank you for our people with the questions. There's one or two things I just want to close out. I want to highlight there's two events happening tomorrow. I'm just going to post the links up here. And there just happen to be two events on EU funding. So it's only relevant for people who's going to stay in the EU, right? So it's there's two events, they're happening tomorrow, and it's all about different aspects of EU funding that's available. So you have the links there on the chat. Now, the other thing, again, as regards newsletters, anyone who's not getting information and updates on the IT of Cork, I just give you the link there that you can subscribe to the newsletter. Even if you are not a member, you can subscribe to the newsletter. If you are a member not getting it, you can subscribe in there also. But thank you very much for everyone joining this session today. And again, Micheál and Mike, thank you very much for very valuable information today.
Thanks for that.
Okay. Thank you all.
Okay.
Thank you.
All the best.
Bye now.